Hi guys, let's talk about Preliminary Declaration of Disclosures, abbreviation PDD. Why is it important? Because if it's not done, your judgment can be set aside. And who wants a final judgment to be set aside when you plan to remarry, have children, and then ex-wife comes back and says, but you didn't disclose this property. So each party in divorce or legal separation must serve preliminary declaration of disclosures. What is that? Form FL150, income and expense declaration form, FL142, assets and debt form. And remember, when you look at this form, it has indication what needs to be attached. So bank accounts, all recent bank accounts, it's the date you sign it. And FL140, which is the form we sign under penalty of perjury saying, this is my disclosure, and FL141 saying, I serve that to my spouse, the preliminary declaration of disclosure. The FL141 is the only form that needs to be filed with the court. The other three forms, FL150, 142, 140, does not need to be filed with the court. You just exchange it. There are two exceptions when it's waived, Code Section 2107, Family Code, and when it's not required, 2110. So in most cases, it is required. Now, when the disclosures are signed, all of these forms are signed under penalty of perjury. And it is required that these forms are served and prepared and served to the other side within 60 days from filing a petition. So since it's signed to the penalty of perjury, any violation, non-disclosure, it's defined and is described in Code Section 2120 to 2129 Family Code, when, if it's not done properly, the judgment can be set aside. And if there is a response filed, then either the respondent has to serve the other side within 30 days from the response is filed or concurrently with the response. So in my practice, I noticed that this rule is taken less seriously because in most cases people just agree to not do disclosures right away, and or they don't do it without an agreement, and nobody really enforces it until it's getting too late, where 2 years passing by, they're just living separately, and then one party decides to remarry, and then everything needs to be done now, and they serve the disclosure on the other party and say, you didn't serve us yours, now we're going to file a request for order asking for sanctions for you not complying with that rule, where you had to do it within 30 days from your response or petition 60 days. So the disclosures have to include 2 years of tax returns. The reason I'm mentioning it because the form FL150, you check it off, but it doesn't say, it asks how you filed your tax returns when the last 2 years, but it doesn't say attach them. So just keep in mind, attach 2 less years of tax return to FL150, and then all current everything to FL142. I had cases where some clients have been asking, well, actually, why should I disclose assets that are located in another country? My assets, I had it before marriage, it's my separate property. All assets outside of California have to be disclosed. Inside of California, obviously, yes. Regardless of the nature of the assets, whether it's separate property or community, it doesn't matter. It has to be disclosed. So another reason to decide if there is non-disclosure of some asset. Even medical trust has to be disclosed. And there was a case where a mistaken belief that an asset had no value was a breach of disclosure leading to set aside. So even if you think that this asset has zero value, disclose it. Also, remember to disclose percentage of ownership. So for example, if you own property with your parents, then you disclose 50%. or whatever the percentage is. Now, aside from the PDD, Preliminary Declaration of Disclosure, there is also an so-called a continuing fiduciary duty to disclose, which is a duty to disclose anything that affects the other side. So if I have an investment opportunity that I am going to use, I have to disclose it to my spouse, even though we're going through divorce. Anything that might affect somehow their either rights or liability, I have to disclose. And that fiduciary duty is defined in Code Section 721, and actually in 1100. And when does the duty end? The duty doesn't end with Preliminary Declaration of Disclosure, not even with Final Declaration of Disclosure. It ends with binding resolution of all issues, including support and fees. So the wife, there was a case when wife stated on the pension in disclosures unknown. The court did set aside the judgment because she was in breach of her fiduciary duty because of her superior position to obtain the records. So let's talk about Final Declaration of Disclosure. So when you look at the form that I just described, 150, 142, 140, 141, those are the same forms for Final Declaration of Disclosures. You just check off the box instead of preliminary, final. And it has to be done at least 45 days before trial. Same forms. No Final Declaration of Disclosures are required in pure default judgment case, meaning in pure default case where respondent A didn't respond at all to the petition, meaning didn't file FL 120, and B, there is no written agreement between the parties. So the parties can also agree to mutually waive Final Declaration of Disclosure. And now it has been different, so it's not done in a marital settlement agreement, it's done in form FL 170 under number 5, and there are boxes to check. So one thing that gets very confused that can lead to set aside of a judgment when someone thinks, oh, we don't have to do Final Declaration of Disclosure, so I'm not going to disclose all these assets that I have accumulated since the date of separation. So 2105D Family Code section states that the Final Declaration of Disclosure is only valid when Preliminary Declaration of Disclosure has been done, both parties exchanged current income and expense declaration, meaning even if you did PDD, you still have to do a year later current FL 150, complied with fiduciary duties, meaning a non-compliance is going to lead to set aside. So if there are any separate property assets, disclose it. Even if you think it's irrelevant, disclose as much as possible. And the waiving party has been doing that, waiving the Final Declaration of Disclosures. I mean, both parties would knowingly, voluntarily, and intelligently, understanding that they have ongoing fiduciary duty to disclose. So it's disclosure on the disclosure and disclosure. So in the divorce proceeding, it's better to disclose as much as possible than in doubt not disclosing at all. So in doubt, disclose everything. There is one caveat that came up January 1st, 2020, that wasn't exempt from family court, which is civil disclosure requirement under CCP 2016.090. And that is a whole different ballgame where it's even more disclosure on top of the disclosure, meaning if a spouse thinks that there is someone who might file a lawsuit or it has to disclose everything, name, if there are any potential claims. Basically, this code section needs to be read and in doubt, disclose again. So I cannot emphasize it enough that disclosure is very important piece of a divorce that cannot be avoided. It's mandatory except in certain cases that I described in default judgment. Otherwise, it cannot be waived. So now you know. I hope that was helpful. I will see you soon. Bye.